Are you struggling with your I-601 or I-601 waiver application? Perhaps you're doing it on your own. Maybe a family member is helping you. Perhaps you hired a paralegal or notario. Maybe you've even retained the services of a lawyer. And you were given recently instructions on preparing a hardship letter, but you're confused. The instructions were skimpy, or maybe you're not a good writer. Perhaps you are a decent writer, but you don't know what to talk about. You don't know how to discuss the hardship to your family if you're removed from their lives. And yet, the success of your I-601 or I-601A application depends on the quality of the letter that you present to the government. Allow me to note, though, that you're not just preparing a letter. You need to prepare a packet. The letter is the center of the packet, but it must be supported by thorough evidence. You must try to back up what you write about with concrete, specific evidence about your family's suffering if you're not allowed to remain in the United States with them. In this presentation, I'm going to outline 6 common points that the government looks at in I-601A and I-601 waiver applications. First, health issues. Are there any special medical or physical problems that either you're facing or your spouse is facing or children have that need consistent and constant medical care? That if you were removed from this country, your family would have a hard time with taking care of those problems financially and time wise and other factors. Is there, for instance, a senior citizen in your family? Perhaps a grandparent of your children from your spouse, or perhaps your own parent, or perhaps another family member that needs your help and you provide the daily care. Those are the types of medical issues that the government will review closely. So you want to provide good evidence. You want to provide medical reports. You want to provide hospital reports. You want to get letters from doctors. Do that to support those issues if they are present in your case. Financial issues are a second common concern that's reviewed by the USCIS offices in adjudicating I-601A and I-601A waivers. But you don't want to make the mistake when you're presenting economic issues to squarely focus on the economic issue. It's the impact of the economic issue on other issues. For instance, does the economic issues, is there going to be a disruption of family activity, the things you have to pay for on a regular basis, rent, mortgage, food? Is that going to affect the family? In that case, evidence like a good daily budget or good monthly budget is good evidence. You want to show your tax stubs. You want to show what things you owe. Maybe, for instance, if you're considering the health issue of a family member, as we discussed just a second ago, you want to present those costs too. Financial issues are important, but they're always going to be related to other issues. Don't just point to the fact that, oh, we're going to lose this income. You want to point it back to the family, tie it together so that the government can see the fuller impact. A third issue is that of education. Are there any special educational issues? For instance, maybe your children are in private school. Maybe there are certain activities they're taking in education. Maybe there's special educational needs. Maybe they need like speech therapy or so. Or maybe your spouse is going to college or special training for improvement in her job, for a job promotion. Maybe you're doing the same. Those are educational issues. So you want to show that. You want to show your children are doing good in school, and without you, there might be a disruption of that. So you want to show school transcripts, school grades. You want to show the cost related to special educational activities. You want to show those types of issues because, again, they point to the family hardship that the government is going to review. Psychological issues are another crucial element of your family's hardship that you want to present some evidences. How are your family members going to be impacted? By either separation or relocation. For instance, if you're going to separate, how is their life going to be affected without your presence there to provide them with the moral, economic, and social support on a daily basis? On the other hand, in some cases, families intend to relocate abroad. But how is that going to affect your children, especially if they're slightly older, that are very, very Americanized, moving to a foreign culture? And how's that going to affect them psychologically? Now, certainly in either situation, you know your spouse is going to suffer some kind of mental distress. So in many cases, a good psychological report is necessary. Now, oftentimes I've seen cases where people come to me and the psychological report is not that good. It's very skimpy. So you want to make sure if you go that route, that you get someone that can really write a good report. Fifth, we want to go into family ties because the ability to stay united with your family is a fundamental criteria of immigration law. What if you have an extended family, either the U.S. spouse or the immigrant spouse have an extended family in the U.S. and the family interacts a lot and they're very close, perhaps elderly parents, perhaps even cousins and relatives, and you spend a lot of time together, the holidays together, birthdays together. What will happen when that family ties are disrupted? Maybe you guys even lean on each other for mental support, financial support, and that's going to be torn asunder. And the other fact that you want to bring up is family ties abroad. Does the immigrant still have any family ties abroad? Maybe everyone's come to the U.S. Maybe all the family members that came from abroad are all now legalized, and the immigrant in this relationship is the only one without legal documents supporting their application. Again, you want to document this issue very carefully. This is where good, strong affidavits from family members will come in important. So again, that shows why I said earlier why a hardship letter is not enough, a hardship package. You can't just say, oh, my cousin or my sister who lives in the city adjoining ours is going to suffer, because her children are very close to my children. You can't write that. Someone has to prepare that. It's a packet. It's a hardship package. Your letter is the hub, but everything else, the evidence has to tie into that. So family ties are a big issue. And sixth, a sixth issue is out of country conditions, which I alluded to a moment ago. Are there family members abroad? What's the safety and security? Is the country that you're from full of chaos, a lot of crime, a lot of violence? Is the employment situation good, bad? Are there any jobs in what you have skills in that you've been trained in? What about medical facilities, especially if some family members that would be relocating with you might need special care, or if even you need special care? Again, you want to document that. That's going to require research into the country, and you want to tie it to the specific region of the country that you plan to move to and why you plan to move to that region. Don't leave that just hanging out there. Tie it together very, very closely because the government's going to be reviewing it again. And again, as you see, the hardship letter is not sufficient. You need a hardship packet. That's very important to proving what you say in your letter. So don't overlook the evidence. The evidence are crucial and must support the letter. Note that these are only 6 issues. There are other issues that could be very important to your case, that could be very relevant to proving the hardship that the government is looking at. But these are 6 issues that are mentioned on the USCIS website that you must closely look at, think about, and then organize your evidence around. There may be others. And so Don't limit yourself to these 6 issues, but do consider these 6 issues, and they will point you in the right direction in terms of gathering more evidence. If you would like more information on the evidence and the process for I-601 and I-601A waivers, I have a 3-video set that you might want to look at. I'll link to it below so that you can see those videos and go into this topic if you're so interested in more depth. Now, here's the key point. When I talk about hardship, remember the government's requirement is extreme hardship, not ordinary hardship, which is why you must be thorough. But in my view, in all hardship cases, I don't believe there's really ordinary hardship. There's only ordinary evidence. And so it's up to you to take the time to prepare. Even if you have paid assistance, you must be sure you guide them and you give them as much information as possible. And they're as inclusive as possible with the evidence, because they don't know your life. They don't know what's going on in your family and how it got there and what they can lose. It's up to you to prepare that evidence. Think carefully about it and then present the evidence. It's another reason why I say a hardship letter is not enough. If you are not an expert in hardship and what to look at, you need to be guided carefully through the process. And I hope this video has given you some pointers on what to do. Because whatever, you don't want to lose your case due to insufficient evidence. You do not want to be separated from your family. With that, take care and good luck. Thanks for watching. Know someone who might be interested in this video? Then please take a moment to like and share it with them. Also, if you would like more videos on immigration, just click on the subscribe button. And here's a little bonus, a short guide that you can download for free by clicking on the link on the description box or the square-shaped image. Plus, if you have ideas for videos you'd like to see, write a short comment below or feel free to contact me at carlos@VitaraImmigrationLaw.com. My name is Carlos Vitara. I appreciate your time and hopefully we'll be talking again very, very soon.